From the News Channel 5 Network, this is MorningLine.
Good morning, everyone. Thanks for joining us on MorningLine. I'm Nick Barris. It's Tuesday, back in the saddle, a live program this morning. I hope if you were off yesterday, you had a great Labor Day, a great long weekend. If you worked yesterday, well, good for you. You have a job, and that's awesome. But hopefully you're watching us now, and we'll open up the phone lines because today we have one of our regular guests with a topic I think, if nothing else, even if it isn't something you think you need to deal with personally, I think it's fascinating. It's very interesting and an evolving part of the law, and what happens when you go to a doctor or a hospital and maybe you feel as though you've been the victim of malpractice, and how whether or not you may or may not have a case. Many people out there aren't satisfied sometimes, and let's face it, with how many people go to doctors and hospitals all the time, these things are bound to come up. So the question is, do you have a case? We'll get into that and take your calls. The number is 737-7587 if you want to join in, not just to talk to me, but to talk with malpractice attorney Clint Kelly. Good morning.
Morning, Nick. How you doing?
How are you, sir?
Yeah. Did you have a good Labor Day?
I did. I was off yesterday, and it's a very pleasant weekend. A little hot, though. I'm really looking
we got
forward.
teased on the front end, and then it got hot again. So,
Steve, I just watched a lot of football.
I did too.
Just lay that out there for you, man.
Of it.
Okay, that's good. That football's underway now, and as we get into this show this morning, you see the number 737-7587. I was asking Clint when he first sat down whether or not there were any recent high-profile cases involving malpractice. A lot of times they'll make news. I haven't seen any high-profile ones locally or really nationally. And they don't always make news. Usually it has to involve a celebrity or something very egregious. But so would you agree? I haven't seen anything of late.
It's been very quiet.
Now, what does that mean? Does that mean they're not happening, or is it just not cases that involve perhaps celebrities or something extraordinarily egregious?
Well, it comes in waves, I think, is how you hear about it. And it depends on the news cycle as well, how busy is the news at one given time. Sometimes if it's quiet, people will begin to report on these things, and when things get busy, they don't. But I don't think there's any schedule to them. It just generally comes in waves.
Are fewer malpractice lawsuits being filed these days than in the past, or is it as active as ever?
In Tennessee, we've seen a reduction in filings consistently over the years. Now, nationwide, I can't speak to that, but I think here in Tennessee, it's continued to show a fairly steady decline.
And I imagine you have a very clear idea why that is.
Oh, yeah. It's because, well, there's a number of different reasons, but the number one reason is the change in our laws here, which occurred actually go back about 7 or 8 years ago when they enacted tort reform and made these cases much more difficult to file and much more difficult to prove.
Okay, so it's just harder to win a malpractice case these days.
It is. It's always been hard, Nick, but it's especially hard now.
What was essentially what was the single biggest change they made that now requires you to prove something that you didn't have to in the past?
They passed what's called pre-suit notice, which requires you to notify the defendant or prospective defendant of your intent to sue, which seems fairly simple and routine. The problem is we went through about 2 or 3 years where the legislature wrote the law. They wrote the law poorly. And so it was difficult for us in the practitioner community to understand what the legislature wanted through this statute. And unfortunately, a lot of good cases got thrown out of court simply because there was a failure to follow that pre-suit notice procedure.
Okay, because is that standard then? Oftentimes when I do malpractice case stories with you or other attorneys, initially I guess it sounds like every time you send some type of letter to the person you're going to sue ahead of time. Right. Maybe one to alert. I didn't know that was required. I thought that's a courtesy, and who knows, maybe instead of taking this to trial, we can get together and work out a reasonable settlement, and that's the first step toward doing that.
Yeah, in every other case besides a medical malpractice case, or what we now call healthcare liability, you do not have to give pre-suit notice.
So just boom, you can serve them with the lawsuit.
Only in these particular cases are you required by law to give pre-suit notice. The idea of the theory behind it was there would be a 60-day cooling off period to allow the defendant to examine his records and make a determination whether or not they want to settle the case, and that happens exceedingly rarely, if at all. I haven't heard of a single case yet where they settled it within that cooling period.
So realistically, from your perspective, why was that passed then? If that's not really, because you're right, that doesn't apply to other cases where there could be settlements. People aren't given 60-day cooling off period. How was this a benefit to the those being sued to get this cooling off
Well, I do
period.
think the concern was legitimate, which was, I think that the idea underlying the statute was to give people time to look at a potential case and say, look, we as doctors don't want to get sued if we can work it out, if we can resolve it. Same with hospitals. But it ignores the practical effect of these situations, which is most of these cases are so contentious that they can't be settled early on, or they won't be settled early on because people's professional reputations are at stake. Or there's sometimes where the patient wants more and deserves to get more out of a settlement and can't come to a monetary agreement with the physician or hospital. So I think the statute had some laudable motives behind it, but in practice it just hadn't worked out.
Gotcha. All right, listen, the number is 737-7587. If you're sitting there and you're joining us this morning and you're wondering or you're thinking of a situation in your case, I always like to have Clint do this. The basics that someone needs to be thinking about. They've left a hospital or a doctor's office and they're not satisfied with the results. Something's happened. What are the questions they need to ask themselves to decide whether or not to give you a call?
Well, first of all, has there been a bad medical mistake? And generally people have a good idea whether something went wrong. Now, you need to have an expert evaluate ultimately, and we'll talk about that later.
But how do you know if there's a mistake as opposed to just a bad result? Doctors can't always cure you.
If there's a bad result, Nick, that begs the question, was there a bad mistake? Okay, so once you've had a bad result, death, loss of a limb, major medical complication, that begs the question of whether there's been a medical mistake. And in order to make that determination, you pick up the phone, you call someone like me, and I'll give the case a review, and then ultimately, if I think the case is worthy of investigation, I'll send the case to a medical expert, and he or she will decide whether or not there's been a medical mistake that warrants a lawsuit.
So you would say then, perhaps by definition, if someone, unless it's a very, very clear-cut cause, has suffered one of those things, you know, just a really bad result, a loss of a limb or a loved one die or something, in the aftermath of that, you should be asking questions?
Correct. Like, I've got a case right now where some people came in from whose son was very young, 16 years old, and went to a major hospital here in town and was supposed to have a kidney transplant. Surgery went successfully. 3 days later, has a blood clot. Now he's brain dead for all intents and purposes.
No.
Now, you look at that situation and you ask yourself, my gosh, this is the most troublesome complication of all, is one that could cause you to be brain damaged. So the question becomes, why did he become brain damaged? We know it was a blood clot. And so the question before that is, was there something done by the hospital or something the hospital failed to do to prevent that blood clot from migrating into this patient's heart and cutting off the blood supply to his brain? And that's where medical experts come to the forefront to decide whether or not there was in fact a medical mistake. But that's one where the damage is just extraordinary, and you need to have it checked out.
All right, and I guess the important point then here, when you're looking at that,
his care is going to cost millions.
Oh yeah, this poor kid,
Yeah.
and is he essentially brain dead now? And
he's basically a vegetable. He can move his leg, but to my understanding, he cannot respond to commands at this point.
This was to be for a kidney transplant,
Correct.
which can be. I mean, any surgery like that's significant, but they're done a lot of the time, right?
Right.
So, all right, I imagine after any kind of major surgery, sometimes there's bleeding and things, so there's steps taken to prevent maybe clots or strokes. So you're going to be looking at whether or not they followed the, again, I learned from him when he comes on, standard of care. Clots sometimes happen after major surgeries. The question is, have they taken the proper steps to try to prevent it? And if it happened anyway, well, what else can you do? Or did they not take those steps? Is that what you're looking at?
That's exactly what I'm looking at. Blood clots, Nick, are the #1 leading cause of preventable death in hospitals today. The Surgeon General said that 8 years ago.
Clots.
They are. And there are many, many ways that they can prevent or reduce the effect of blood clots either before or right after surgery. Usually it's through an injection of an anticoagulant like heparin or some other type of blood thinner that will prevent the clot from forming. Also, you've probably seen patients who have these sleeves on that squeeze and inflate and deflate. That's part of the general strategy to try to prevent clots from forming and migrating, and so hospitals have been doing much more over the last few years to incorporate those strategies to prevent things from happening like what happened to this poor kid. The question becomes, in this particular case, did this hospital do all the right things they were supposed to do to prevent this boy from being badly injured?
And how far do they have to go to prevent something like that from happening, and whether they went far? Yeah, that's interesting. We'll talk a little bit more about that. We've got some calls coming in. Lisa and others, 737-7587 is the number. If you will, just hang on. We've got to take a quick break. When we come back, we'll start things off with Lisa and continue to get into the basics of what you need to know and what you need. And we've just started covering this. We've got to talk about statute of limitations, too. We'll be back right after this. Stay with us.
We've got a call.